beautiful opportunity that God has given us to meet as usual and share or discuss on things that matter in our society. I'm very happy to see you again. So glad, and this is a Franciscan platform, Franciscan family, but we always invite even non-Franciscans to join us so that we have a common ground and platform of discussing on the various topics that we have. And I'm so happy also that our guest speaker of today is already with us. Thank you so much, all who are joining from every corner of Kenya and East Africa. I'm seeing people from Uganda, Tanzania, Kenya joining us. Hopefully, we'll have also others from abroad, Europe and the US. As usual, we always get some guests to join us from there. So as you join, go to chat box, introduce yourself, greet audience so that we get to know each other. We get to know also who is joining from where. It's good that as we meet, even though it's online, it's very also possible to keep connection, to keep this network, to keep the dialogue. If it is your first time also to join this platform, yeah, you put your email address or phone, WhatsApp, so that we can be updating you when we have this kind of dialogue. So my name is Stephen Kezamutima, moderating from the Office of Justice, Peace, Integrity of Creation Franciscans Africa. So I'll be the moderator of today as usual. And I'm happy also that our guest is already with us, Mr. Charles Kanjama. Before we start the talk of today, I would like to invite one sister in this platform to give us an opening prayer. I'm hoping that Sister Rose Mwangi, if you can hear me, can you give us an opening prayer? Then I will invite Sister Mary Wangari Sebastian, the Director of Justice, Peace and Integrity of Creation Franciscans Africa, to invite the guest of today. Welcome, Sister Rose Mwangi.
Yeah. Good morning, Stephen.
Good morning, Sister Karibu Sana.
Peace and good. Yeah, thank you. And also peace and good to everyone. It's nice to be back. So let us pray. In the name of the Father, and of the Son, and of the Holy Spirit. Amen. Our Heavenly Father, in gratitude we come before you this morning for together with our Father Francis. We also continue to praise you because you are the author of creation. We are part of that privileged creation, coming together as brothers and sisters to listen to you, because every time we are talking about peace and justice issues, as we get ready to listen to the issues of the BBI, enlighten us with your wisdom, guide us with your peace, with your hope, inspire also the speaker of the day, and prepare us to be instruments of change, instruments of peace and justice. We make our prayer through Christ our Lord. Amen. In the name of the Father, and of the Son, and of the Holy Spirit. Amen.
Thank you so much, Sister, for this wonderful prayer. I welcome you once again, and I would like to inform you that this talk is already live on YouTube. There is a link that our host has already shared. You can pick it from chat box and share it with the other friends or partners that you have. They can follow also from wherever they are, or even after this Also, I would like to request that from wherever you are watching, following, yeah, it's good that you mute your microphone so that we don't have get any sounds, background noise to disturb our speaker of today. And when time will come, we'll unmute your microphone so that you'll be able to contribute. Thank you so much. As also you keep discussion in chat box, is good also to be to remain ethical, to remain uh, Christian or Muslim or Protestant. I know we are here from different perspective, interfaith. We have people from Baha'i who are already with us here, waiting for others also to join. Thank you so much. Without delaying this, at this juncture, I would like to invite Sister Mary Wangari Sebastian, the Director of Justice and Peace, Franciscans Africa. Sister Mary, would you like to invite our guest of today? Kindly.
Thank you, Steve, for giving me this opportunity. My dear Franciscan members and our friends, partners who are within this Zoom meeting, I'm humbled to introduce and to welcome our guest speaker, Charles Kanjama. The time that since I knew Charles Kanjama, when I knew him, I was working with the Association of Sisters of Kenya, Justice and Peace Commission as a coordinator by then. And I was in the Commission for Justice and Peace as one of the executive. And I met Kanjama in different places. As a Catholic who is very committed, giving the bishops the advice on the way forward, especially on the issues of the just 2010 constitution that we are talking, we want now through BBI to amend it through referendum. Issues of abortion, if people will remember the time that FIDA and other partners who are promoting that the abortion should be in the constitution, and other issues that he has been able to advise us as Catholic faithful with his knowledge. Kanjama is a well-gifted man of God. He is from Kenya Advocates. He is a lawyer. He has his postgraduate diploma in law at the Kenya School of Law. He is a lecturer at the Strathmore School. He is a Catholic professional. And what I know that is that he's a junk of so many careers. He's an accountant. He has done commercial law, including banking and insurance, employment law, public law, law litigation, criminal law, succession law, family law, and children building construction, so many others that he has done. When you look at Kanjama, with all that he has, that's why I started saying that he's a blessed man, he is a gifted man, and Kanjama is using his giftedness by the Lord to empower others to understand more. And this day in particular, he is going to take us through the BBI, and we understand it, lead it, we understand it, and make our informed choice in either way. We remember that the other Saturday, I went through the letter of our bishops with you in the Zoom, and many raised so many questions. I hope this session will be an interactive one. For those of us who do not belong to Kenya, I hope that you will enjoy being here and you get something that may build you on the other side. So Charles Kanjama, you are most welcome. In this forum, you get the Friends of the Franciscans, but more so is for the Franciscan Family Association. You are most welcome.
Thank you, sister. I hope you can hear me clearly. Okay, fantastic. So I've been asked to give an outline about the BBI, the Building Bridges Initiative. And I'm going to take some minutes to do so, maybe 20 or 30 minutes, after which you can have an interactive session, which I think is the main reason why we are having this engagement. But it's always good to establish a background. So good morning to everyone who is present. Once again, I'm delighted to be here. My name, as you've been told, is Charles Kanjama. I'm an advocate of the High Court of Kenya. If you have challenges at any moment hearing me, please let me know. I'm an advocate of the High Court of Kenya, and I've been involved in constitutional matters, constitutional cases in the courts, constitutional commentary for more than 10 years. I've been involved in several cases involving the change in the constitution and interpretation of important provisions of the constitution and implementation of the constitution. So I'd like to start by giving a brief background of how we got where we are right now on the BBI. And the background, of course, begins in 2010. In the year 2010, in August, in the month of August, I think it was August 4th, Kenya went to a referendum. And the purpose of the referendum was for Kenyans to decide whether they wanted to replace the Independence Constitution of Kenya, which had been amended numerous times since independence, with a brand new constitution. And Kenyans eventually decided by a majority of 2-1 to adopt a new constitution. And this became the Constitution of Kenya 2010. This constitution was promulgated on 27th August 2010. So we commemorated the 10th anniversary of the Constitution 2 months ago, actually 3 months ago. And as Kenya Christian Professionals Forum, together with the Law Society of Kenya and other professional groups, we decided that that day of promulgation of the Constitution, we shall in future commemorate as Katiba Day. So this Katiba Day, 10 years ago, 27th of August, the Constitution was adopted in Kenya. We know that in 2010, a big segment of the church leadership recommended that we oppose the adoption of the Constitution. The main reason being that there were some clauses in that document which were harmful to values of family values, values of life, to our moral values, and basically matters of practice of religion. There were not many, but there were some. And it was felt that it was important to first amend the document before it is passed, so that those harmful provisions do not endure in the Constitution. The political class, however, assured Kenyans that the Constitution can be passed and amended later, and that no Constitution is perfect. Let us first pass it, implement it, and when we see where it is not working very well, we can always change it. So the Constitution passed based on that political promise of the politicians. After the passage of the Constitution, we spent 5 years, which was the period prescribed in the 6th schedule of the Constitution, implementing the Constitution. This was what was called the transition period. The transition period was meant to last until 2015, and it included the first general elections under the new Constitution, the elections of 2013, in which for the first time in Kenya, we had 6 elections in one occasion. And we elected county governors, we elected members of county assemblies, we set up the county government structure with those elections. And we also elected senators who we did not have before. And the senators were going to be the second house of parliament that was meant to secure devolution of the county government structure. In those 5 years of transition, we also implemented numerous acts of parliament. The parliaments were passing laws, 30, 40, 50 laws per to implement the constitution. So we had also a very dramatic transformation in our legal structure. We passed new marriage laws or family laws. We passed new land laws. We passed new business laws, company law, laws on partnerships and so on. We passed numerous laws on elections, political parties to change the democratic governance structures. We passed laws to implement the constitutional commissions that had been set up under the constitution. We split up the Kenya National Human Rights and Equality Commission into three because we thought that the role that was given to it in the constitution was too much, and the constitution allowed that split. So we passed a law for the National Gender and Equality Commission, for the Commission on the Ombudsman, that is the Commission on Administrative Justice, and then we had the Kenya National Human Rights Commission. So there were three commissions created out of one. We started the process of restructuring the police service, the public service, the judiciary. The vetting process of judges and magistrates was undertaken. It took 5 years. So there was a lot of work that happened. And with the first county government structure and Senate, there were numerous teething problems and challenges. And the Supreme Court had been set up, and it was requested numerous times to give advisory opinions, to interpret various provisions of the Constitution when there were instances of conflict. There was conflict in Parliament between the National Assembly and the Senate. There was confusion about the role of cabinet secretaries and whether they can appear before Parliament to be questioned, and confusion between the Senate and the governor. The senators wanted to have their own Senate, you could call it county development fund, similar to the constituency development funds that MPs have, and the governors opposed this. So a lot was happening. But as all this was happening, we started seeing transformation in our governance, in our structures. The principles of Chapter 6 about ethics, with the resistance, they started percolating down. And so it is now 10 years since that new constitution came into place, and we've gone through a long process of implementation. And in 2017, we had a general election, which resulted in the first ever court decision cancelling or overturning the result of a presidential election in Kenya, in East Africa, and I think it was probably the second in Africa ever. So it was a major and dramatic moment. And of course, we saw that during that presidential election, you had the typical episodic, every 5-year ethnic mobilization on the basis of negative ethnicity, corruption associated with elections. And so after that first election and the overturning of the election results, there was a moment of crisis when the opposition coalition, that is the NASA coalition, decided that they will not go into fresh elections. You remember all this very well, until there were fundamental reforms in our laws and a change of the commissioners in the Electoral and Boundaries Commission. And there was confusion. The Supreme Court had not been very clear on whether changes of this kind could take place. And the government of the day pushed ahead, IEBC pushed ahead with the process of new elections. And we had the new elections where the opposition coalition basically boycotted the elections and told their supporters not to vote. But the elections were then declared valid by the Supreme Court, and Uhuru Kenyatta was re-elected for his second term with his Deputy President William Ruto. But there was still a lot of violence and tension. When I say violence, I meant roads being blocked, a few other instances of violence, and people were shot in riots, some lost their lives. And then you had the swearing in at Uhuru Park of what was then called the People's President, Raila Odinga. So it was in this period of tension that the handshake occurred. Uhuru Kenyatta, the president, Raila Odinga, the former prime minister, came together and had this memorable handshake, and they said, we can come together and work together. And it is the product of the handshake that generated the Building Bridges Initiative. And the whole idea of the Building Bridges Initiative was to explore why do we keep having every 5 years all this deep polarization on tribal basis, on with a lot of corruption coming in. What is wrong with our country? So after they went around the country, they sourced some views, and the makeup of the task force included representatives from the religious sector, including the former Bishop of Kisumu, who was one of the members of the BBI task force, was a representative from NCCK, from the EAK family, the Protestants and the Evangelicals respectively. And then there were others. But all this was being driven fundamentally by two principles. And we started seeing the beginning of a political rift or tension, where the deputy president and his supporters felt that they had been left out of this new initiative. And yet the president kept insisting that the same way I came together with the deputy president in 2012, 2013 is the same way I now want to come together for purposes of peace and unity. So we went through a period of collection of views, and the BBI came up with their first report. It was a very well drafted report, and it was trying to reflect on what is wrong in Kenya. And it identified the key problem in Kenya as a problem of our software. In fact, that is the term they use. They said we have a problem of software. The software means that our culture, our values, the way we've internalized them, we as a people, there's something wrong with the way we work together with one another. That even if you keep changing the laws, if you don't change the software, we will always have a deficit in our governance structures and process. But nonetheless, BBI report number 1, which I will call BBI number 1, proposed how to deal with this deficit of software at 3 levels. The first level was the level of implementing policies and internalizing our cultural values, our national values through education. So the first level was, you could say, the soft level. I'm talking now as a lawyer. The soft level did not require any legislative change. Maybe improvement of the curriculum, improvement of how we are educating people, and passing of some policies which can be done by the executive, because the executive is the one that implements policies after enacting the policies. Then the second level was the level of legislative change. BBI number 1 proposed that there should be some changes to some acts of parliament. And the proposals for the changes were made in a generic way. There were not very specific recommendation of amend this provision of this law like this. But there were generic proposals, for example, saying that we need to change IEBC. We need to get out the current commissioners, get in some new commissioners. We need to implement aspects of gender and so on. So there were some proposals for legislative changes. And then thirdly, there were proposals for constitutional amendments. And the proposals for constitutional amendment included introducing the position of a prime minister, having 5, you could say, key positions. Right now you have 2, the president and the deputy president, like the senior positions during contests in the general election. So they wanted this to be increased to 5 by addition of a prime minister and 2 deputy prime ministers, who would then be carrying out government business in parliament and would be part of the cabinet. So there was a proposal to have the position of leader of official opposition. And there were a number of other proposals, but the proposals were made in generic terms, a kind of like as a principle, not as a specific amendment required in the Constitution. So when BBI number 1 was released, members of the public reviewed it. There was a lot of response, some positive, some negative. There are also concerns about the process. Many people in civil society, even in the religious sector, were saying that there was not a very structured way of getting views from us. Some of us struggled towards the last minute to present views, but things were not very well advertised. The public participation in coming up with BBI number 1 was not as effective, for example, as what we did when we came up with the Constitution of 2010. And there was a recommendation that there needs to be more public participation, even something akin to the Bomas Conference. The principles, after receiving the criticism and also realizing that the first BBI report was incomplete because it did not have those specific and concrete legislative proposals, it had general recommendations on legislative amendments, then extended the term of the BBI task force. And now the BBI task force was given the job of coming with those specific proposals. You see, this is now a process of legislative drafting. It requires lawyers, technical experts to reduce the initial proposals into a clear technical document of how we'll change our laws. At the same time, I think BBI was meant to now receive views from those who had reacted to the first BBI report and maybe revise some of the general proposals that had been made in BBI version 1. So BBI version 2 was a bit more open in terms of receiving views from stakeholders, not so much from the public. In fact, they decided to go around the country popularizing BBI 1 in rallies. And in a political rally, you cannot really be receiving views or sober views or reasoned views. You cannot be engaged in a process of deliberation. It's more a process of polemics or polemical engagements. And of course, we know the political temperature had begun rising. And then the coronavirus pandemic came to our shores. It hit us in Kenya like it hit other countries in Africa and the rest of the world. And there were several changes or regulations that came up to reduce public gatherings. And this affected the process that was ongoing of BBI, at least public participation. But the task force kept working, and they eventually, at the end of was it June or July this year, their term was coming to an end. They finally announced that we have our now BBI number 2 report, BBI 2 report. And this BBI report is ready to be presented to the principals. And at that time, the Prime Minister, former Prime Minister Raila Odinga was a bit unwell, or at least he had traveled out of the country for some medical intervention. President Uhuru Kenyatta also had some engagement. So for a period of 2 to 3 months, actually 3 months, we kept wondering when will the BBI report be released, until last month in October, when in this public event at Bomas of Kenya, the report was released. And as the experts, we then studied the report. The report that was released on BBI had again 3 key areas. One area on the policy proposals, very specific. A second on proposed bills, amendments of bills and new bills to implement some of the proposals in BBI. And then the heart of the matter was the constitutional amendment bill. This is a bill to amend our Katiba. Our Katiba is the Constitution of Kenya 2010. So this is now what has caused the most focus, because the proposal to amend the Katiba, which is our foundational law, is the one that has the greatest ability to transform or change, alter our governance arrangements. So when this report was released at Bomas of Kenya, you remember what happened in the speech of one or two of the speakers, most particularly the deputy president. A number of items were raised of concern that this BBI number 2 report, which now has a constitution amendment bill, is going to cause some injury. It has some provisions that are good, but it has some that are not good. We could say that are bad. And you remember the deputy president in particular identified a few of those provisions. The proposal to change and restructure the governance of the police service from a police service commission that works on the governance arrangements, and then you have the Inspector General on the command structure, to create now a new body called the National Police Council. And then there was a proposal also to remove the administrative police, to merge the administration police with the National Police Service into one police unit. And a concern was raised because this National Police Council was now going to be chaired by the Cabinet Secretary or Minister in charge of Interior. And this was going to personalize and politicize the governance in the police service. Another issue that was raised was about a new office that was being created of Judiciary Ombudsman. That office already exists under administrative arrangements of the judiciary with the current constitution. But the proposal under BBI number 2 was now to make it a constitutional office where the ombudsman is appointed by the president and is a member of the Judicial Service Commission and is given the job of investigating judges. And so there was a fear that this will significantly affect the independence of the judiciary. So this was another issue that was raised. And there were 2 or 3 other issues that were raised of this nature, including on the question of the Electoral and Boundaries Commission, Independent Electoral and Boundaries Commission, IEBC, where the proposal was to add political appointees by political parties, together with the technical person, so that you'll have a commission of 7, where half of them are political appointees to run elections. And this became a matter of concern. A few other points of concern were raised, but those 3 stood out. So at this stage, various stakeholders started giving their comments after reviewing the bill. Many people in civil society were not happy with the BBI process, even before the number 2 report was released, because of concerns about the process. They felt that this constitutional moment that President Uhuru Kenyatta had mentioned a few months ago was a contrived constitutional moment. It was merely a convenience, political convenience of our head of state who is in his last 2 years in office. And they had fears that a president who is in his last 2 years in office and is about to leave should not be so committed to changing governance structures, especially if they are meant to give more power to the presidency after he leaves. And they're wondering, why would you want to give more power to the office when you are leaving? What is the catch? They also felt that governance issues were being diluted, including the proposals on introducing the Prime Minister and the 2 deputy Prime Ministers and the alterations to the Senate and the National Assembly. So the civil society has been almost 90%, based on my own analysis, opposed to the BBI process and outcome even before the report came out. And when the report came out, they just re-emphasized their opposition. And so people wanted to know, what is the view of professionals? What is the view of the church sector? And the professionals have not issued a very broad statements, but they have, in some professions, they have expressed concerns here and there. Doctors were concerned that the health commission that they had been requesting for had been omitted. Stakeholders like governors were concerned that they were now being forced to ensure that they are deputies of the opposite gender. Most of them already have a deputy. Some of them are eligible to run for another term. It would mean they have to fire the existing deputy to look for a deputy of their gender. Women were concerned that even though they had been given the seats to meet the gender principle in the Senate, because the Senate was now being expanded to 94 senators, so that each county will have 2 senators, 1 man and 1 woman, and there would be equality. The women seats in the National Assembly, 47, had been taken away and been replaced by 70 special election seats or multi-member seats, where there was no formula to determine the gender. So instead of the gender being improved, it was being reduced. The senators were concerned that they had lost the current power that they have to veto the division of revenue bill, and they felt the Senate was being weakened. So there are all these concerns that were being raised by different stakeholders. A professional body like the Law Society of Kenya, because of being a bit caught up in some internal divisions, had not yet issued a very firm statement, even though since 2019, August, when the Law Society of Kenya's annual conference took place on the topic of the Constitution, the position of the Law Society of Kenya has generally been that what Kenya needs is to fully implement the Constitution, not to amend it. And so important voices in the Law Society were saying, let's implement the Constitution and not give politicians an opportunity by creating openings for amendments to distort our constitutional structure. The church sector was a bit more measured because many of the people in the faith community were in 2010 in the No campaign, or in the No team rather than the No campaign. They were opposed to the Constitution and they were saying, let's change those provisions. And the provisions that the church was concerned about, if I can mention them very quickly, Article 2 was introducing international law into Kenya. And international law, we have less control over it. Other countries may decide to use mechanisms to generate principles in international law opposed to our faith and values. And there are concerns about it. There are concerns about Article 26 on the right to life, in particular paragraph 4, that was allowing abortion in limited instances. And the fear was that it would be expanded, especially read with Article 20 and 21 of the Constitution. There are concerns about Article 27, which was talking about non-discrimination, that it will be interpreted very widely and might even go into things like LGBT or the gay agenda. And all these concerns of the church that I'm talking about have actually been proven right in the last 10 years. There were concerns about Article 32, the specific formulation of the right to religious freedom, as narrowing the right for religious practice and religious engagement in public space. There are concerns about Article 45, the one on the family, that again, it might create openings for a breakdown of families and entry of foreign ideologies on the family. There are some concerns with Article 43, the phrase that talked of reproductive health care as being another possible channel for introduction of sexual and reproductive health and rights ideology and comprehensive sexuality education, which are harmful foreign ideologies. And actually, this has been proven true over the last 10 years. So these were the main concerns that the church had. And the church was saying, can you change these things? Of course, in 2010, the church had also expressed concern with the Kadhi Court provisions. But since between 2010 and 2020, because the Kadhi Court provisions were retained in the new constitution as they were in our independence constitution, that issue was kind of like placed aside. And by the time 2020 was getting around, the faith community was no longer talking about Kadhi's court. Their only concern was any proposal to expand Kadhi courts, because the current arrangement of Kadhi courts in the constitution is a compromise, where The courts for the Muslims have been put in the constitution, but for Christians, there's nothing similar. So the compromise is the courts for the Muslim personal law issues remain in the constitution, and the Christians will deal with their matters either in their churches or they go to the civil courts. So that was like a settlement. And so the issue of Kadhi's court was not an issue in 2020 in terms of change to the constitution. The only issue was that because there were some proposals to expand the role of Kadhi's court, what I got from the Christian faith community, what I was hearing is that they did not want that expansion. But that issue was left aside, so it is not really an issue right now. So the faith community still wanted their issues to be addressed, because they had been promised in 2010 that when the time comes to amend the constitution, they addressed, and they were totally not. On the other hand, there were governance proposals, some of which key members of the church were in support of, like expanding the government to have a prime minister. There are some, like in the NCCK team, who felt that this might help to lower the political temperatures at the time of election. So the faith community was not completely on one side, but they were a bit skeptical about certain proposals, because the church cannot just talk about issues of faith and morals. As citizens, Christians as citizens can also talk about governance issues. And we know from the Acts of the Apostles that when the early church started preaching, at the same time, they started taking care of the poor, of widows, distribution of food, matters of health. And we know that is what the church has always done, part of its missionary activity. Establish schools, establish hospital, medical facilities, because you cannot just take care of people's souls and ignore their other bodily needs. The two have to go together. So the church was expressing concerns, but not really taking a position at that stage. And ultimately, what the church was doing was recommending a dialogue, more dialogue. So in this process, the principals, I think, realized that in order for them to cobble together a coalition that would become a majority for political purposes of ensuring the BBI passes, there may be need to do a few revisions to the constitutional amendment bill in BBI number 2. And yet, what was being requested by the faith community, what was being requested by civil society and other stakeholders, was that this BBI number 2 should be reopened to public participation, to stakeholder engagement, even to a constitutional conference. So people kept giving statements, press statements, public statements, but for some reason, the principals and their supporters who are under the BBI process, they felt that any such reopening will slow down the implementation of BBI. And for some reason that is not clearly explained, there's this sense of great and extreme urgency that the constitutional amendment bill must go to a referendum by July next year. And there's a feeling that you cannot have a constitutional amendment, a significant constitutional amendment, 12 months before a general election. And because the general election is in August 2022, the feeling is that there's a very limited window for going through the entire process to get to the referendum. And the principals want a referendum. And of course, different people involved in the process always have different motivations. Some are overt and some are covert. Some are open and public, some are hidden. But everyone, apart from their stated position, also is trying to do some political jostling and positioning. And we can tell that these are preliminary kind of like positioning to prepare for 2022 elections. And of course, the faith community, civil society does not like the fact that the BBI process is now being, on the contextual level, politicized or being used as a political tool for 2022. That instead of it appearing to build bridges, which is what it is stated to be doing, it is actually being used to break bridges and create political alignment so that the politics is superior to the governance desire. And so there was this pushback of, let's slow down. We don't even have to do it next year. Why are we doing a BBI constitutional amendment process when we have coronavirus? So all these voices were coming. And at the same time, the politicians were saying, no, you guys, you don't know what you are saying. What we have is good for the country. If the church wants to vote no, let them vote no. In any case, in 2010, they supported no and they lost. We are ready to deal with them politically. And then civil society's voices kept being raised, but not being taken very seriously, because civil society also needs to persuade Kenyans. And yet the situation on the ground, the grassroots, is that many Kenyans are very skeptical about this process. They don't feel the constitutional moment. They feel that economic issues need to be taken care of first. And at the top political leadership, the politicians were jostling, how do I benefit from this process? So while this was taking place, there's a small team, technical team, that decided now to change a few of the proposals in BBI number 2, because they felt those ones were going to make BBI number 2 fail to get political support. And that is what led to the event that happened this week, where a new Constitution of Kenya amendment bill that we can call BBI number 3 was now released. And this time it was only the amendment bill that was changed. And this amendment bill, I'll try to share on my screen so that you can also see what it says. I don't know whether you can see what I'm sharing. Is it visible? Sorry, I will try to share it now. Okay, so if I'm not able to share it, I hope one of you can. But so the BBI number 3 is now the bill that I want to discuss briefly, after which we can proceed with the rest of the session. Are you able to see my screen? I can, okay, fine. You can see my screen. So let me try. Okay, I've now maximized the amendment bill. It's on the right of my screen, and I hope you can see it. So this Constitution of Kenya Amendment Bill 2020, let's call it BBI number 3, because it is what has been launched this week. And it was launched together with the commencement of signature collection. In fact, the day it was launched is the day signatures were collected. The surprising thing is that in that ceremony where signatures started being collected, people started signing just after the bill was launched. They had not even read the bill. They had read the previous one, but the new one, with the changes in the new one, had not even been read, but people started the signature process. So before going to address the substance of the bill, I want to give a broad overview now of the product so that we can agree how do we assess whether the bill is good for us or not good for us. And there's no document that is perfect. There's no document that is totally imperfect. So it's always a question of judgment. How do you exercise that judgment? So as Kenya Christian Professionals Forum, which I chair, we recommended, because we are from the faith community and we're also professional body. So we kind of like are on both sides. We said that the professional approach is to assess the BBI document using a 3 layered analysis. First, to look at the process, because you cannot just look at the the document without looking at the process that has given rise to the document. Second, to look at the substance. What is it that the BBI Constitutional Amendment Bill is proposing? And then thirdly, to look at the context. What is the context in which we are being asked to do this amendment? Is this context favorable or not? Is this the right time? Whether it is issues of COVID or the cost of a referendum, is this the right time? Should we tolerate it because of the benefit we want to get? So that's three-tiered analysis. What is important for us to do. That is number one. Number two, and this is a discussion I've had with some of the technical persons who have been involved with myself in reviewing the Constitution of Kenya Amendment Bill. There's this Western movie that came many years ago, several decades ago. It was called The Good, the Bad, and the Ugly. And the title is very fitting for this kind of analysis. When looking at the BBI bill, are we able to identify those provisions that are good? And there are several, because nobody sets out to create a bill, at least not in Kenya, with a deliberate intention of harming Kenyans. People don't do that. And of course, we know in the BBI task force, there were eminent Kenyans. So there are good provisions. And then there are some which are, they're not matters of principle, they are matters of preference. And so you can choose, maybe you prefer Prime Minister, maybe you don't. It's a political issue. It's not a matter of principle. But maybe the way it has been implemented is not adequate. There are some weaknesses in the implementation. So this is then what we can call the bad. There may be potentially good provisions, but they have been poorly implemented in the draft. And then finally, you have what you could call the ugly. So what is the ugly? The ugly would be poison pills. You see, if somebody gives you a cup of tea with some dollop of sugar or some teaspoon of sugar, maybe the tea is very healthy or very, very nice, very tasty, very welcoming. But if there is a tablet of poison, there is a poison pill, you will not take that cup of tea. You will not tell yourself that because most of the tea is good, it even has sugar, I'll take the tea if there is poison. So if there is a poison pill, the poison pill is enough to make you say no to the tea and the sugar. And so then what we'll be asking ourselves is, are there any poison pills or potential poison pills in the BBI document? And I think that is a critical analysis. What is the good? What is the bad that you can live with, maybe? And is there any ugly that you cannot live with? And we'll be looking at the substance, the process, and the context. Before I now come to the substance, I want to say something about what happens after the presentation of the BBI for signature collection. And I will summarize this because it's a constitutional process by saying that the BBI Constitutional Amendment Bill could have used one of two paths for amendment of the Constitution. One path is what is called the parliamentary path, and that is the path that is foreseen for government proposed amendments to the Constitution. The parliamentary path under our Constitution requires you to get 2/3 majority, both in the National Assembly and the Senate. You present the bill directly to Parliament. For any constitutional amendment bill, there has to be 90 days between the first reading and the second reading. After the 90 days, if you're able to get 2/3 in National Assembly and the Senate, then the bill can be passed. And of course, it is possible under our Constitution of Kenya 2010 for the proposal to be amended and maybe the process to start again with the first reading of the bill, so that if there are any provisions that are considered poison pills or not well drafted, so bad provisions, they can be redrafted and the process begins again. So the advantage of the parliamentary process for government bills is it involves more consultation,
more possibility for reviewing the provisions and improvement during the process of enactment. Once that bill passes with 2/3 majority in both the National Assembly and the Senate, it is then required to be presented to the President for approval or for sign-off. But if there are any provisions in that constitutional amendment bill that are what we call entrenched provisions, that is, provisions that are altering important sections of the Constitution that have been listed in the chapter on constitutional amendment, like the term of the president, like the question of the structure of parliament, independence of the judiciary and constitutional commissions, the chapter on Bill of Rights, any constitutional amendment bill that goes through the parliamentary process and that includes some provisions that affect entrenched provisions has to be subjected to a referendum. Not the entire bill, but those provisions that are considered entrenched. So the parliamentary process sometimes can end without a popular referendum, but where there are entrenched provisions involved, after Parliament has approved, it will still go for the referendum. That is the approach that initially many civil society persons anticipated that the BBI process will follow. It now seems that when the politicians who know politics more than anyone else, they are successful in politics, when they looked at the BBI process, they must have concluded that the parliamentary process will not suit them for a number of reasons. And this is my reasoned speculation. One, they probably not be able to get 2/3 majority, either in the National Assembly or the Senate, or that in the process of trying to get that 2/3 majority, there will be a lot of controversy and possibility of alteration of some of the provisions that they hold dear, that are hidden in the bill, maybe even a bit camouflaged, but that they hold dear. I think second is that they felt that by going to the people to collect 1 million signatures, and I will explain this other process, they are able to politically reorganize the political dynamics before 2022. Because I think all the top politicians are already positioning for 2022. So there was a political arithmetic. Let us go to the people. Let us take advantage of this situation to disrupt certain coalitions or political coalitions that are already been set up. So they decided to go for the popular initiative. How does the popular initiative work? It is anticipated under the Constitution to be an initiative begun by any citizen of Kenya, any person who wants to amend the Constitution. Popular initiative is anticipated to be one that does not involve very dramatic and multiple changes to the Constitution, a few. And what the idea is that once you identify those few changes you're interested in, you then come up with a constitutional amendment bill. You, as the promoter of the constitutional amendment bill under the popular process, are meant to ensure that you do public participation, you engage the people, so that you come up with a draft that might get the support of the people. And then you go around the counties collecting 1 million signatures. From all the counties, you collect signatures from different counties so that you have 1 million signatures in total. And you present the signatures to the Independent Electoral and Boundaries Commission. You tell them, I've got signatures from Kenyans who support my proposal. IEBC is now meant to verify the signatures. This is the process that was followed by the Punguza Mizigo initiative of Ekuru Aukot and his political alliance or party. And under this approach, the reason why you would go through this process of IEBC is because they need to confirm that 1 million genuine Kenyans have supported your initiative. So one of the problems that was faced with the Ekuru Aukot is this, that there is no referendum bill or referendum act in Kenya today. So even though the constitution prescribes the process of doing the popular initiative, there is no act of parliament giving the details. The second problem is that there is no register of signatures of Kenyan citizens with IEBC. IEBC doesn't have that register. Their voters register doesn't include those signatures. So that the registry of persons have signatures that they can do verification. They have the mechanism. But IEBC doesn't have it. So that even in the case of a Kuru Court's initiative, when the signatures were presented to IEBC, IEBC did not have the facility, the mechanism, or the infrastructure to compare a digital signature with the signature on the register, the forms that were presented by a Kuru Court's team. And then the question came, how does IEBC confirm that 1 million genuine Kenyans have signed this request for popular referendum? But IEBC, because they were under pressure, the previous time when NASA tried to do a popular referendum or ODM, they had rejected some of the signatures. So this time they allowed the signatures of a Kuru Court, even though they could not verify them. Basically, the only verification they did was a verification of names, not a verification of signatures. And then once IEBC verifies the signatures, and the constitution does not provide the time limit, IEBC can take 1 month to verify signatures or names. They might even take 6 months. So it is a very problematic process. But once IEBC does their job, it's then meant to go to the counties. And from the 47 counties, you're meant to get at least half of the counties approving the constitutional amendment bill. So the challenge here is that, again, there is no obligation of the county assemblies to consider the bill. There is a timeline for the counties to approve the bill, I think 3 months, but there is no obligation. So when a Kuru Court transferred his bill to the county assemblies, I think only 3 or 4 county assemblies considered this bill. The rest ignored it. Once 90 days had passed, his popular amendment bill collapsed merely because of inaction of the county assemblies. So that was another problem. But if you now succeed with the county assemblies, that bill that has gone through the county assemblies now is presented in parliament and only requires a simple majority in the National Assembly and the Senate. And even if it doesn't get that majority, I think it still requires 2/3, but even if it doesn't get that majority, it doesn't fail because it goes for the referendum as a complete bill. The challenge with this new process of popular amendment is that there is no opportunity to pick and choose. You can't say, I like Article 10A, but I don't like Article 250A. You can't say that. It's a package. Take it or leave it. And that is why 2 speakers of county assemblies have already filed an advisory reference seeking an advisory opinion from the Supreme Court. They did that this week, I believe, asking, when you have multiple proposed amendments that are not related, they're on different points, is it a requirement that you have a multiplex referendum? Instead of one referendum question, yes or no, do you accept this package or you reject it? Several questions. Do you accept the changes on Prime Minister? Yes or no? Do you accept the changes on cabinet secretaries and cabinet ministers? Yes or no? So then that is an issue that has not yet been determined, but that is the general process. So now that I've talked about the process that is being followed by BBI, they are in the stage of collecting signatures, I'll very quickly look at the issue of the Constitutional Amendment Bill. I had shared my screen, but I think it has been unshared by someone. So I'll just request you to trust me if you are not able to see my screen, because I now want to start scrolling. And I'll do very quickly. I'll not take long because I want us to have the discussion on the good, the bad, and the ugly. Article 10A is a proposed new article in the Constitution that is going to talk about regional integration and to allow the states to take measures to promote political confederation in Eastern Africa. Is this good, bad, or ugly? I think everyone has their view on the matter. Personally, I think it is potentially dangerous because political confederation affects the structure of our governance arrangements and should not be undertaken without a very specific and concrete proposal for constitutional amendment that is presented to Kenyans for discussion. But under Article 10A, it then makes it possible, after this constitution has been amended, for an act of parliament to then dramatically change our governance arrangements and create a political confederation without further referral to the people of Kenya. So it is a point of concern. Article 11A is again a totally new article on economy and shared prosperity. And it is basically saying that the Constitution should recognize the need for an economic system that provides equitable opportunities for all the people of Kenya to benefit from economic growth. This is an article that creates soft law. It's like principles. The state should promote productivity by promoting intellectual property rights, sustainable sources of livelihood. These are kind of like desires. It's a good clause. In fact, I would support it. I like it. It's a kind of clause that is improving the Constitution. Then you have Article 18A. This is the third brand new article. This article is on responsibilities of a citizen. And it is basically saying that every citizen has a responsibility to cultivate national unity by respecting Kenya's ethnic, intellectual, economic, and cultural diversity, promote and protect the well-being of the family, including respect for their parents. This is fantastic. And Professionals Forum, we are extremely delighted with this idea of promoting and protecting the well-being of the family, practicing ethical conduct, combating corruption, fulfilling parental responsibilities towards children. So it's a fantastic clause. In fact, one of our concerns in the past has been that we have a very well done or very elaborate chapter on the rights of citizens, or Bill of Rights, not just of citizens, of all people in Kenya. And then we don't have any provisions on the duties of citizens. At least the provisions that are there are just about paying taxes and so on. But on one article that now tries to capture some of the responsibilities that citizens have, this is very good. It creates a bit of balance. So this is a fantastic article. So you see, so far, the three articles I've mentioned, majority of them are good. There's one which is potentially problematic. The others are good. The whole chapter 4 of the Bill of Rights, which is the biggest chapter in the Constitution, has had only one minor amendment to include among the right to privacy, the protection of personal data. And of course, this is positive. It is meant to reassure those who are concerned about Huduma Number initiative that their data is going to be infringed. And I think it's a positive provision. And of course, for the church, their concern is that all their recommendations for amendments in this chapter, dating back 10 years, have been ignored. So that omission is a concern for them. Article 80 of the Constitution is being amended. This is on chapter 6 to introduce a responsibility for EACC, the Ethics and Anti-Corruption Commission, and other bodies involved in implementation of chapter 6 to carry out effective and expeditious investigation, prosecution, and trial of cases relating to this chapter. So this will strengthen the Office of the Director of Public Prosecution, will strengthen EACC, will even strengthen the courts involved in prosecution of corruption cases. This is a positive addition. So you see there are several positive additions. Article 82, which is in chapter 7, is chapter 8, is on the question of gender principle. the women leaders in our country have been complaining that we've not implemented the gender rule. And then the issue is, it says that political parties, it has given the responsibility to political parties to ensure that when they are doing party primaries, not more than 2/3 of their candidates in the general election are of one gender. So this is fantastic. It has created a mechanism for securing the 2/3 gender rule organically. And with Article 82(1)(f) alone, you'll be able to achieve gender principle without the need to restructure the Senate or the National Assembly. Article 87 has also now provided an amendment that the political parties tribunal will be able to deal with cases arising from nomination of candidates by a political party through legislation provided by Parliament. So all those provisions so far, generally good. There are some concerns about omissions and concern about the provision on East Africa Confederation. But you see, those are the preparatory. So what I'm trying to say is that in the BBI version 3 and also in BBI version 2, there are several provisions that are actually improvements. They are good. And then now is where we come to the provisions that start becoming troublesome provisions. And the first is Article 89 of the Constitution, where the number of members of Parliament in the National Assembly are being increased from 290 to 360 by an additional 70. This is not for purposes of securing gender, for those who think it is. It is for purposes of dodging a previous constitutional requirement that every 10 years you must revisit constituency boundaries based on the population of the population census results. So the first revisiting was meant to happen now. So the whole idea of Article 89 has been presented to Kenyans as we don't want to have the counties or the constituencies with small population lose their current members of Parliament because they'll be forced to be merged. So in order to preserve them, we now need to increase the constituencies for the ones that deserve more. So you see, there are some counties like Nairobi, based on population, deserve more constituencies. This is under the Constitution and the formula that is there. So instead of taking those constituencies from the counties that under the current arrangement will be forced to lose some constituencies, let us increase the number of constituencies. And the new constituencies will not be single member constituencies. These extra 70 constituencies are what are being called multiple member constituencies. It's not clear how this will work. It will require an act of Parliament, but most likely, if Nairobi has, say, 16 MPs, and then they add an extra 10 seats, which are multiple member, the 10 seats don't have to be specific geographic or region demarcated. There might be 10 seats for Nairobi as a whole, so that you can either vie to be the MP for Dagoretti North or Dagoretti South or Embakasi East, or you vie to be the MP for Nairobi number 2 constituency, which will be a constituency that might be as wide as the boundary of the entire Nairobi. So the multiple member seats don't follow the traditional structure of single member constituencies. They have a wider geographical region, but they have multiple representatives. That's the idea. So this proposal was put in BBI number 2 of the additional 70 seats. But to create the 70 seats, BBI number 2 removed the 47 women reps or women MPs who represent each county, one for each county, and also removed the 12 nominated MPs who represent youth, persons with disabilities and special interests. So those 59 seats were eliminated to create this new 70. And so the women leaders were very concerned. They said, gosh, you've actually you've reversed the reserved gender seats Of course, the idea was that because we've taken it to the political parties, we no longer need the reserved gender seats. But the women were not convinced. So now in BBI number 3, they have still retained the extra 70, but they have still added an additional provision saying that in the event, after we have these 360 MPs, we find that women are below 2/3, we will nominate additional women, or there'll be a party list for those additional women to reach at least 1/3. So this is the same mechanism that is used for county assemblies right now. What has been the experience with county assemblies? That very few women MCAs are elected directly, because in the direct election, the male candidates use the argument that, women will still be elected using the special process. So if you give me this seat, we will still have another person because the woman will come in through another process. So what has happened is that the top-up seats, let's call them the top-up seats to ensure the formula is attained, tend to be quite high, and they increase the size of county assembly significantly. So if this happens to the National Assembly, potentially, if you have 360 MPs, it means you might have up to, arithmetically, up to an extra 180 women MPs under the top-up formula. Of course, the number will be a bit less because we know some women will be elected directly, but that will be the maximum. So that from 360 now, the size of parliament has gone up to 540. But in addition to this, there is also a proposal to change from the presidential system to a hybrid system, which is what we had since independence. And instead of having cabinet secretaries who are technical people outside parliament, to have cabinet ministers, so that the heads of ministries are members of parliament. The only difference is that before they had to be appointed from, in our independence constitution, they had to be appointed from among MPs. Right now, they can be appointed from outside MPs. But once they're appointed, they automatically become MPs. So that gives the president an extra 22 possible slots that he can fill with people who have not been elected, and then they become ex officio MPs with the right to vote. That adds the number of parliament potentially from 540 to 562. And then in BBI version 3, in addition to the 22 ministers who are in BBI version 2, they've added another 22 assistant ministers. And even though the BBI version 3 is silent on whether the assistant ministers will be MPs ex officio as well, I've read very carefully the provision, and my conclusion is that an interpretation of the provisions as they come out is that those other 22 assistant ministers will also be MPs. So that takes the number to 584. And then, of course, you have the leader of official opposition, prime minister, deputy prime minister. So you might find the National Assembly approaching. The number will not be definite. It will change from each election to the other, but approaching 600 MPs. And I think this is a general concern for Kenyans, how we are almost doubling. We are increasing by more than 50% the number of MPs in the National Assembly, and also increasing the senators from 66 to 94. So those are some of the challenges. And then the other thing they have done, they have reintroduced the members of parliament to take care of special interests, youth and persons with disabilities, that had been removed in BBI version 2. So that is an extra 4 members plus another 2. So there'll be an extra 6 members. So that is just the formula that for parliament. And then one of the concerns of civil society is that we are going to reintroduce the imperial presidents. Imperial president means the president is less accountable to the people. He has less checks and balances or controls. If you have a prime minister and the prime minister can be fired by the president, then that means even having a prime minister doesn't introduce a check and balance to the president. One of the checks in the current constitution is that cabinet secretaries and other key state offices must be approved by parliament. So parliament can decide, no, we don't like this person. And that has happened before. Under the proposals in BBI, the presidential appointments for the Inspector General of Police, for cabinet secretaries, will no longer be subjected to parliamentary approval. So those are some of the concerns. Of course, many people in the faith community think that the proposal for leader of official position is a good proposal. We need the person who finishes runner-up in the general election to come into parliament. The problem is that the running mate of the runner-up has not been recognized, only the runner-up himself. And then you have the provisions on the prime minister and the deputy prime ministers. And there are several provisions, Article 151A, B, C, and D, that provide for how the prime ministers and deputy prime ministers shall operate. The confusion here is that the prime minister is appointed from the coalition or the party with the majority in parliament. So what happens if the president comes from Jubilee after the elections? I'm using the current situation. But then, for some reason, in parliament, majority of MPs are from ODM. Under the way the constitution, BBI version 3 has been drafted, the president will have to pick a prime minister from the head of ODM. So then the question then arises, how will he operate with a cabinet where the prime minister is actually from the other coalition? And he can appoint that person and then fire him. So it is quite confusing the way they have implemented the issue of prime minister. Then, because the time has gone very fast, I'm going to summarize the other issues very quickly and say that the provisions on the ombudsman, who is to be appointed by the president, have been retained in BBI version 3. So he shall be approved by the Senate, but he becomes a member of JSC. He's the one to investigate complaints against judges and discipline judges. Sorry, no, he's the one to receive complaints against judges and investigate them. And that is a concern, because it means that the judiciary will be threatened in quotes by someone who's a presidential appointee and not an appointee of the Judicial Service Commission, or at least not a nominee of the Judicial Service Commission. So that is an issue of concern. The other issue that has been dealt with is the one of the police. They have removed now the National Police Council. They have retained the Police Service Commission. The only problem is that the Police Service Commission, the power of the Police Service Commission on human resources to discipline police officers has been taken away and given to the Inspector General, which creates a danger that we will again personalize the police service, which was one of the problems of the post-independence Kenya police that we were trying to resolve with the 2010 constitution. On the question of CDF, they have now established under the constitution or entrenched the Constituencies Development Fund and the Ward Development Fund in the constitution. This is meant to be a sweetener for MPs and MCAs to support the BBI bill. But governance experts are saying that this is a bad move because that CDF and the Ward Development Fund are outside the normal financial structure of governance and oversight that has been structured in the constitution with the Commission on Revenue Allocation, the control of budgets, the parliament and the county assemblies as oversight and not executing organs. So there's an issue there. The shift in the power of the Senate to the National Assembly to determine the division of revenue between the National Assembly and the Senate has been retained in BBI version 3. And then there's been the implementation of the 35% minimum allocation to counties to increase from 15%. This is also an issue of concern because the increase in the cost of government is something that is a concern. However, on the surface, it's very good to increase the amount of money that is going to the grassroots. So this is a matter where people have different views. They have established a youth commission. What the youth commission is meant to be doing now are things that were initially being done by the National Gender and Equality Commission. They have returned the administration police that had been removed in BBI version 2. It has been returned in BBI version 3. And those are really the main changes in BBI version 3 to the Constitution. I'm sorry I've taken a bit longer than I was meant to, but you now have an overall view of what BBI wants to do. And I think from here, we can now discuss the good, the bad, and the ugly, and what is the role of the church. Thank you.
Thank you very much, Mr. Kanjama, Charles, for this great presentation. Very, very rich. Some of us, maybe we've not even known that there was BBI version 1, version 2, version 3. So we are learning a lot. Some of us, we've not also not yet read this document enough to really understand all those dynamics that you've presented to us. Yeah, we really appreciate you for taking us through all the process of BBI from the backgrounds, historical background. I would like to invite participants to also give appreciation to Mr. Charles. Put it in chat box. Some have been putting some remarks appreciating and also asking some questions. So I would like to open this floor to participants now. If you have any question, any comments, make sure you make your question clear so that Mr. Charles Kanjama can also help us to understand more. Yeah, because the way I've learned from him, I'm wondering if, like, I'm joining one that Kamau has already put in chat box. How is it understood by common mwananchi? Like what we've learned just within this hour. It is so interesting. I'm not sure that all citizens are aware of all this involvement and these dynamics into BBI. So thank you so much for this. And then I open the floor to participants. Welcome. You can open your microphone and ask any question. Also put in chat box your comment or question if you don't like to speak, but the floor is open. Welcome. Unmute your microphone. And put your, Thank you for your appreciation. You are putting in chat box.
Okay, so as we wait for any question, maybe I can look at the questions in the chat.
Yeah, sure.
And even in the chat, I'm not seeing questions. I'm just seeing comments. But there's one comment I can comment on, which is now I see why the bishops are asking to separate issues than subjecting the whole document to referendum. And I think the bishops in the statement they issued at Subukia when they had their plenary meeting, and also
bishops of or church leaders of the other partner umbrella church organizations like NCCK and PAK have also been making very similar comments. You'll find that the comments or statements issued by the church leadership in different churches have been quite similar. That let's have more dialogue and let's not just have one package, because there are some things in the BBI proposal that are positive and there are some that may not be positive. So that is an important point. And as I wait for questions, let me add something else that I think is very important. In the year 1992, Kenya had substantial constitutional amendments. And this was the clamor for multi-party democracy. And after Daniel Moi yielded to the clamor, we changed the constitution to allow multi-party democracy to come back. And it required several changes. And one of the changes that we introduced in that constitutional amendment was a change that brought in a 2-term limit for the president, or the presidential election. So a president could only serve for 2 terms. This was done in 1992. And the question that arose is that when the amendment was done, the president was Daniel Moi, and he had already done 3 terms. And so there was a legal question. The legal question was, is Daniel Moi, because he has already done 3 terms, should he then quit office, or is he entitled to an additional 2 terms? And the answer to the legal question was that because the structure of governance has changed substantially now, the 2-term limit will start counting from now. So Daniel Moi then was entitled to 2 terms because the term limit was a fundamental change in the governance structure. And so one of the concerns is, if we have fundamental change in our governance structure with BBI, based on our previous legal precedent, will it mean that the 2-term limit for our current president, Uhuru Kenyatta, starts running afresh? Is that an issue that might come up? And this is an omission, because under the transitional provisions of the BBI Amendment Bill, it would have been very easy to say that the provisions of this bill shall not be construed as increasing the number of terms for those who have a term limit under the Constitution. Unfortunately, they have not done so. So that is an issue of concern. As we keep talking, I have seen some questions that have now been asked. So I can deal with these questions. And then after that, anyone who wants to talk can raise their hand on Zoom, and we'll give them a chance to talk. So Richard Kaketo, who also is a lawyer and very experienced in this matter, has asked, what is the position or possible direction of the faith sector with regard to the contentious issues of 2010 that seem to have been ignored by BBI 1, 2, and 3? And I think that's a very critical question. The faith sector has not yet made a final determination of what their direction will be. But there are possible issues that are being considered. One is to see whether BBI can still be reopened for further discussion, both on the proposals as well as the omissions. That seems unlikely, but there are some who are still holding out hope that this might be possible. Number 2, there are those who are saying that we may need to have our own bill, so that if BBI, despite all the concerns, continues being forced through the process rapidly, then we also have our own bill, so that when Kenyans go to the referendum, if the expense is already being incurred, then they can also decide whether to vote on those few amendments that will deal with the family values position of the church. And the third option is that the church continues its engagement in the courts, in parliament, to clarify those areas where the church has concerns, and where, of course, the opponents of family values are also engaging to try and push their agenda. So I think those really are the three possible directions regarding the contentious issues. There's a question from Paul Nyaga. In summary, what are the roles of the president and the prime minister? What I would answer is that the president remains the head of state and the head of government. He remains the chair of the cabinet. He remains the one in charge of policy formulation and implementation. But because under the BBI version 3, as well as version 2, government also has been received back into parliament, the leader of government business in parliament, which is where lawmaking and oversight is done, then becomes the prime minister. So the prime minister will be a member of the cabinet. And as a member of the cabinet, he will be number 3 in the hierarchy of cabinet. There'll be the president, the deputy president, then the prime minister. The same way that currently cabinet secretary of the interior, Matiang'i, has been given the delegated responsibility of chairing certain cabinet committees, the prime minister will have that delegated responsibility. He'll be able to chair cabinet subcommittees after the president determines which subcommittees the prime minister can chair. So the prime minister, as the head of government business in parliament, will probably have a prime minister statement every so often in parliament. He'll answer questions. He will coordinate other cabinet ministers to answer questions by MPs on government business and so on. So that's the role of the prime minister. The prime minister must have a majority of parliamentarians supporting him, so he can be removed by a vote of no confidence and can also be removed by the president. That is more or less the difference. But the president retains all his current powers. There's a question from Isaac. Would you kindly help to put into perspective the burden to the taxpayer? And my answer is that the burden to the taxpayer that you are saying was substantial with the 2010 constitution is going to be increased probably by an extra 25%. This is just my rough and ready estimate in terms of government payroll. I'm not talking about repayment of government loans or government debts. You know, there's another dimension of government expenditure that goes towards servicing loans, towards capital expenditure. I'm talking about recurrent expenditure. It's going to have a significant increase because of the budget in parliament increasing, and also because of the increase of the minimum amount going to the counties from 15 to 35%. This may be good if it is used well. If it is wasted the way we waste a chunk of our budget through corruption, then it will be negative. So of course, when there's a burden on the taxpayer, it always depends. Are you using that money to benefit the interests of the taxpayer, or is it being wasted? Then the next comment, there's a question from Marianne Cheruyot. The political class seems to be moving a huge wave towards this document, given that it has introduced punitive bills. How are we in the church going to ensure that our people are well informed? I think through sessions like the current one, once you become well informed, it's like a training of trainers. Once you are trained, you can train other people, you can educate other people through sessions like this, engaging with the media, etc. How can we stop the expense of 14 billion against the current economic crisis facing the nation? That, I assume, is the amount that will be spent in the referendum. There are some people who've gone to court to try and get clarification of aspects of the process. You can ask your representatives in the county assembly if you think they should not approve the bill, not to approve it. You can demand of IEBC that they be rigorous in verifying the signatures and the names. There are many things you can do, but you may not succeed because that is a political process. Those who are promoting the bill may be the ones who will succeed. And of course, there are Christians also among those promoting the bill. So it's really a political contest. From Bernadette Wanza, why do our leaders close their ears to the cry of the common mwananchi and want to even make it heavier for the same people that voted them in? I think there's a lot of politics in the current constitutional moment that we have had being talked about. And politicians, the first thing they think about is attaining power. And that is of politicians all over the world. They do that. If you don't think of that one, you will lose the elections. And unfortunately, sometimes they do it, they abandon principle for the sake of politics, which is unfortunate. Sister Rose is asking, which criteria are they using to collect signatures from the public? Any person whose name is in the register of voters is allowed to give a signature, and they need to have signatures from all the counties in Kenya. And so what they are doing is they have established groups to lead signature collection in every county, and then they will collect the signatures that way. Marianne has also asked, what is the position of the church on Kadhi's courts? I think I explained this at length in the presentation, but I'll summarize by saying that right now the church leaders are saying, let us leave the Kadhi's courts as they are because it is a compromise, and that might be the most convenient way of doing it. Holland's Odhiambo is asking, how can Mwananchi spearhead the amendments into this bill to remove or refine ugly articles? This is a very important question. Once the signature collection has started, the bus has taken off. You can see that the plane that is on the runway has taken off. And once the plane takes off, it's impossible to embark or disembark until the plane lands again. So unless they restart the process of signature collection after getting new amendments, the popular process does not allow removal of the ugly articles or the poison pills in the documents. Teddy Abonyo asks, what is your opinion on retention of healthcare management by the county? You know, I have many doctor friends, and I know many people who are stakeholders in the medical sector. And I know that a big number of them would like a healthcare commission that creates some role for the national government. But I also know that the counties and many people who have benefited from county intervention in healthcare, at least the new facilities that have been built and so on, are very strong that the counties should retain the role of healthcare management. So where there has been mismanagement of healthcare professionals are very concerned that the sector has been really mismanaged. There needs to be some intervention. But does that intervention require that we remove the healthcare role from the counties and take it to the national government? I think that is a question that doesn't have a very clear yes or no answer. Then John Dungu is saying that I've touched on the context. In my view, is the time ripe for changes to the constitution, all things considered? I think my personal view is that the ideal time to have a referendum would be when you are having the 2022 general election. That is what is done in, for example, the United States of America, and I've seen in several other countries with presidential systems. It allows you to make a saving because you don't need to have 2 elections every 5 years, you just have one. And it also allows you to distinguish the politics of the referendum from the politics of personalities, because the politics of personalities is happening at the same time. So people don't use the politics of referendum to position themselves for the politics of personalities, which is the politics of election. So for me, I would think the context is not very positive because of COVID, because of the forceful money that is going to be incurred, and yet our economy is not doing well. And also because of the fact that we are not giving the process enough time for people to discuss the kind of amendments they want and to have options, not packaging the good, the bad, and the ugly together. there is a question that when people say this amendment makes the president an imperial president, is it true? And I think my answer is that it depends. You see, the phrase imperial president is one that has been used a lot in academia to refer to certain aspects of the exercise of power and power relations between the president and other governance agencies that make the president less answerable to the governance structures and to the people, less accountable. My view is that the amendments that have been proposed have an overall effect of reducing the accountability of the president. And that means the trend that has been implemented in the amendments is towards, in the direction of, an imperial presidency. But you see, this is a spectrum. Have they reached the level where you now say it's an imperial president or not? I think that is a very debatable point. But definitely, the amendments move in the direction of less accountability for the president. Then there is a question from Holland Sodiambo again. How well can we lobby MPs to ensure that proposed bill suits Mwananchi? You can do that, but you realize that the MCAs will have more power under the popular amendment process. So you have to lobby both your MPs and your MCAs. This is the time to find out who are your MCAs, wherever you come from, if you are currently resident in Kenya. So I think I've dealt with several of the questions that have been asked on the chat, and it will be very good to at least get a few verbal, oral questions and comments. So I now request 2 or 3 of those listening, raise your hand, unmute your microphone, and speak, not for more than a minute, for half a minute or 1 minute, either make your comment or ask your question. Thank you.
Sure. Thank you so much, Mr. Charles. If anyone would like to speak, just unmute your microphone.
Okay, once again, thank you, Charles. Can you hear me?
Yes.
Okay. Once again, I thank you, Mr. Charles, and I thank the participants who are very, very alert in listening to this talk as we try to understand the BBI. There is one thing that I've liked, the depth, the deposit of software. I think it is a challenge to all of us, which software is missing in our lives. And especially when I read the comments from the participants who are really wondering, how will others know? When we sat down as Franciscans, we thought that it was good to create awareness through the Zoom meetings that we have every Saturday. And that's why we resorted into today's Zoom, so that if we have touched more than 100 people today, then those 100 people replicate this knowledge to the other members. I'm sure the Franciscans who are around here, they have ministries that they work and they meet people. If at all, if each one of us could take a responsibility of explaining to each and everyone you meet what is in the BBI and what is supposed to be done, what you understand, maybe this will help. I remember during the 2005 referendum, which was the first referendum towards the constitutions. And I went home and I met the women. I heard women talk under the tree. And they were all talking about oranges and bananas. They don't eat them. They eat this since they were born. And when I woke up, I went and asked them, Mamas, do you know the color of the book that you are talking about? And they said no, because our MP, our chief, our community leaders have talked and they have told us that we cannot eat banana, we cannot eat oranges, we eat bananas. So what am I saying here is each and every one of us here is a challenge, has a challenge to go and share the correct information with those who do not know. I've seen people asking whether they can get this book, but I am sure that you can get it. We don't have any in our office, but you can get them at the government place, I'm very sure, and you can buy one for yourself. So the other thing I would like to say is public participation, as Mr. Charles began with, is very important, but we're in a scenario where our government is just doing his own public participation to gain and to get what they want out of this, then we will lose. So we really need to see what are the public forums that we can share these issues. Even if you are in small Christian community, you are a religious person in your own community, share with these people. So once again, I thank you and may God bless you. Let us not break the bridges, but build the bridges well.
Okay, thank you, sister. I've seen there's a hand up now from John Dungu. So John Dungu, please ask your question or make your brief comment. Please unmute.
Right. Can you hear me now?
Yes.
Hello.
Yes. Proceed.
So I like to start with a quote. St. Augustine says, given a choice between good people and good laws, he will go for good people, because good people can make good laws, but good laws cannot make good people. So the idea is that I'm thinking now in terms of the long game. So we have to try and encourage people, of course, to participate in this process. But I think everybody also has to do their role. If you know someone who's a potential leader, to encourage them to join the leadership. And if you know someone, you have contact to some of these people to try and waken up the conscience in them so that they realize the effect of their decisions and their call. Because some of these people pushing all these things are Christians, and some of us can do to them and do a bit of a process with them and make them realize that the world depends on them and the decision that they make. So basically, we can change all the laws we want, but if we don't change who we are, as you say, the software, it's just an effort in futility. I think that is what I'd like to say for now. And we don't have to be politicians, but it could be just financing a good politician or a potential good leader, or just giving him a word of encouragement. Thank you.
Wow, that is a very fantastic contribution. I think both Sister and John Dungu have given very good contributions, that change of people comes before change of laws. And even when you are changing the laws, let's continue changing the people. There's also a hand up from Holland's Odiambo. Holland's Odiambo, you can unmute your microphone and also ask a question or a comment for 1 minute.
Thank you very much, Mr. Charles. This was such a wonderful opportunity for me to understand this bill. I remember I read the what you are calling BBI one now, and I was so impressed with it. I was wondering why there were so many people who were opposed to it, but then yes, there are issues. What now I'm beginning to understand, especially from this space that was created, that there's a lot of misinformation that is going on around, because when you watch the news, even some of our church leaders have grossly misrepresented some of the things that are here. So I think it's going to be a challenge for us as the church and people who care deeply for this country, that we initiate this even at the grassroots, because I think the civil societies are kind of not doing a lot of civil education. So this is the way to go. And you've mentioned something at the end that there's going to be a lot of importance, especially when it comes to the M. So we also do that when the time comes, we can put the right pressure on our MCS to make the necessary adjustments to the law. Thank you.
Okay, thank you, Hollands. You've also given a good contribution. That was also a comment. So both MPs and MCAs are going to be important because both of them are going to have to interact with the law. But MCAs interact with it before MPs in their county assembly. But all of us will be interacting with the law from now as citizens of Kenya. And I think MPs also have a chance through motions in the National Assembly and the Senate to discuss the ongoing process that is starting with collection of signatures. So let's not ignore the MPs, even though in terms of the technical process, MCAs deal with it with MPs and have more weight. But in terms of the political dimension, MPs have more possibility of influencing the process. So I think both are important. I'm not seeing any other hand up, so maybe I can look at the last few questions and comments on the chat, and then after that, I give my final comment and we close at least my portion of this session. So the other comments that I have seen in the chat, there's one from Euphrasia. BBI as a document points out many problems, but fails to embrace and take the reality. Many Kenyans truly lack a moral choice because of lack of information. BBI is claiming to unify Kenyans, but it may not be actually doing so. So this is just a comment, and definitely nobody should be rushed either to accept or even to reject BBI. We have to do reasoned deliberation, and then we make our decisions, prudential decisions. Then Kibe asks, how does BBI address the issue of winner take all? I think many have commented that BBI does not address very much the issue, but there are some things that BBI does that at least help, like the creation of the post of leader of official position and making the leader of official position a member of parliament. That at least is positive. The issue of having 5 senior positions might allow more people to feel that they are involved, especially when you have a country that has strong ethnic alignments. But those people who come from smaller communities will still feel that they have been kept aside. And even the winning coalition might have a token representative from one of the larger communities who does not really represent their community. So there's an attempt to address winner take all. I don't know whether it is very successful. Ever asked where it is possible to get copies of the BBI report? They have been circulating on WhatsApp, and there's also from Hollands a comment with a link to where the bill is in our website, theelephant.info. So if you go to the chat and you click on that link, you'll be able to download the Constitution of Kenya Amendment Bill. This is the BBI version 3. It will also be good to get BBI version 2 and version 1, even though what will be up for debate for the referendum is the version 3 BBI document. So those are the comments. I think I've dealt with them. Maybe I can make my final comment and then hand it back to the organizers of the forum to close. So I'd like to say that I've been delighted by this session. When you prepare a session like this, you also learn as you are preparing and presenting. So I think, and also listening to the questions and comments. So it has been very enlightening for me as well. I think as citizens, we should not fear taking positions and participating in the political space. And the BBI process, even though we would have desired more consensus, is a process that involves a political dimension. So we will have to get involved as citizens. For the church, I think the church is concerned on matters of faith and morals, because those are issues of principle, and then also concerned in matters of governance, where there is an element of principle as well as an element of preference. And the church can give some guidance, but leave the decision making to the faithful. So at the end of the day, it is up to all of us to keep educating ourselves more, to educate the people around us, to engage, to participate, so that we can ensure that this process of restructuring our governance arrangements ends with an outcome that is for the good of our country and the good of our people. Thank you very much. Have a nice afternoon.
Thank you so much, Mr. Charles Kanjama. This was really a wonderful moment of learning, sharing, and I'm hoping that we shall have more opportunities to discuss on this particular document and the issues related. Before we end the session, I would like to invite Father Haman to appreciate the guest speaker of today, and also make a few remarks. Then we call it the end. Haman, welcome. Unmute.
Now, fine, thank you. Can you hear me? Hopefully, yes. I was a great listener today. almost 40 years in Kenya, to seeing so many changes in politics, in our social and our political constituencies and surroundings. Who is winner and who is loser? There was one commentary there. What does a ordinary Wananchi gain from it? Or is it really a process deepening democracy, governance of people? So I hope it is like that. I hope hopes are fulfilled in this way, and expectations that it is really reaching out to our demanding areas, to the slum areas, Kibera, Mathare, whatever the names are, so where people are gathered together really and living in low standards of life, that they have a gain from it. That would be, we should not miss to mention this. It is governance, is a purpose of service, of ministry, of involvement for betterment of others, that this is really expressed there. So my hope, I was in some meetings with the religious of preparing for the BBI concept. So I'm happy to see now that the final step is almost reached, and it will be presented, published, and will be discussed upon and embraced upon, that we say we can gain from it, we put our efforts in, we identify with it. I identify with my being in, I'm now a foreigner, but that the Kenyans say it is my concept, it is my participation, it is my contribution, it is my involvement. So there are some commentaries from my side. The Lord be with you. May the Almighty God bless us, the Father and the Son and the Holy Spirit. Professor Charles Kanjama and Sister Mary Francis, Stephen, all who contributed, thank you, thank you. We had rarely such a big gathering I have just to say, it is our, since we do our Franciscan Zooming since more than 6, 7, 8 months, we close it for the time of December and we reopen it in January. And hopefully we have a common program for then the forthcoming month in the new year, 2021. It is coming. So tomorrow, starting Advent and a new Church of the Year, God's blessings, preparing for Christmas, how it may be turned individually, in communities, in societies, in our churches. We take it what we can, adapting to the needed adaptation concerning coronavirus. God bless you. Have a nice weekend. See you again. Merry Christmas.